I started off this little conversation with the Goodness Chavez cases, and so
Yeah.
the last two aren't so good. The other one, again, trying to tailor this. I don't want to come at you with all the asylum cases. They get published every single month, and a lot of them are so nuanced to the facts. But this other board decision, matter of Kagumbas, which, because it's a board decision, it's binding on USCIS, but it's not really so much about USCIS, it's about immigration court. But then the USCIS attorneys, the USCIS officers know it, and it essentially says that even if USCIS has approved an I-130 petition, an immigration judge has the authority to
Yeah.
find that the marriage is not bona fide. So, I mean, an I-130 is necessary, but advisory.
Yeah.
It's kind of a matter of Kagumbas. And I mean, realistically, I talked about Ira about this case, and he was pretty up in arms about it when it was published. But like realistically, if an immigration judge believes an I-1 marriage is not valid, they're going to deny adjustment of status as a matter of discretion.
Yeah.
Like, you probably weren't getting adjusted if the IJ isn't convinced on the validity of the marriage even before this, but now it puts it squarely within the statute and allows an immigration judge to find that the marriage is not bona fide, which then could actually lead to, I-130 denials in the future based on other marriages and stuff. And, to be honest with you, you only get so many facts in these decisions, but the facts didn't seem that egregious in matter of Kagumbas. It seemed like actually the wife and the husband testified decently consistent, and Mr. Kagumbas was the one who was trying to push this along immigration court. So, sound like he thought he had a good case, but
Well, it goes to strategy. Now you could have like adjust in court, or you could adjust and you could request. I mean, at least before Trump, I remember you could go into administrative closure, something like that, and the judge would close the case, so you could do your adjustment with USCIS. I guess as a strategy, I don't go to court. I don't deal with this. I just knew you could request that either judge do it or USCIS do it. Always push if you can for the judge to kind of close the case for USCIS to do the adjustment. Now, am I talking? Does that make sense, or is that still something that's possible?
yeah, I mean, administrative closure is back if you want to go, and at least in Miami, it seems like ICE wants to. If they're going to agree to anything, it's going to mostly be termination over administrative closure.
Mm-hmm.
But if they do get it administratively closed, you should try to get it terminated before your guy or woman, before your client adjusts status, because then when it comes to naturalization, we were seeing during the Trump years that USCIS was taking the position that the person was still in proceedings, so they did not properly adjust status because they were admin closed rather than terminated. And I don't agree with that argument, but you'd rather not be making legal arguments with USCIS at the naturalization stage, especially with everything that's on the line. So if you're going to admin close and adjust, try and get them to terminate before the interview. Although, but that's not possible, right? We send these emails to ICE and it goes into the ether. So for right now, termination seems to be what a lot of ICE offices or some ICE offices want to do over admin closure, because I don't know, it helps with the backlog and it just kind of transports it to USCIS.
Well, yeah, I'll take a termination over admin closure. I guess that's better generally, isn't it?
Well, with admin closure, I think the complaint is with admin closure, you're still work authorization eligible so long as you have an application pending, I guess, and not the case with termination. But I guess the presumption is you're going to file your application with USCIS.
Yeah.
And also, if you admin close, if it's like a work visa type adjustment, if you admin, and you correct me if I'm wrong, but we've talked about this before. If you admin close, you still got your application pending before the IJ. You're in a status authorized by the Attorney General.
Yeah.
But if you get it terminated, you have no application pending. If you're out of status and it's a adjustment application based on a marriage to an LPR, for example.
Yeah.
You won't be in status on the day that you refile before USCIS. I mean, you might just shoot yourself in the foot, shoot yourself in the face.
Yeah.
And so it's a really
it's like immediate relative, primarily marriage kind of stuff that pops up.
You got to get it admin closed in that case, or else you are risking a big problem, because even though an adjustment application automatically goes from USCIS to the IJ, I don't believe that it goes automatically from the IJ back to USCIS.
And one other note you made with regard to like Trump era, the coming back and naturalization, saying you're still open in court. I have a case right now, which is like it probably doesn't need a waiver, but I just said, listen, file the waiver to the client because I'm like, I don't know in 5 years from now when you adjust because the waiver is a good case. I'm not going to do the waiver case. I don't do waivers, but they had a really good fact, so I'm pretty sure that the waiver would get approved. And the alleged if any misrep was so benign that I think it's an easy 601. But I'm like, just do it because a lot of lawyers on like Facebook are like, don't bother. But I'm like, 5 years from now, we don't know who the president's going to be and who's going to be leading justice, who's going to be leading USCIS,
Yeah.
And they might come back like, well, you should have got a waiver, or something like that. Do something that's going to hassle us. Say you adjusted inappropriately, you didn't do this, do that. So it's kind of like you have to throw in the kitchen sink now to be careful because we don't know the future, and the future is this pendulum swings so rapidly in the polarized system that we have. Just do everything you can right now to protect. Think like 5-10 years down the line.
Yeah, it's hard. It's a strategy call, right? I mean, you can't often if we don't think that there's fraud, like we'll often check no on the box and then
Yeah,
explain it later. I mean, so if you explain it, I don't think that there's an argument that you withheld anything, even though you said no. You explained it on the 45, and then you explain why you don't believe it's fraud. I mean, we've done both. Just preemptively file it and also argue it's not fraud. But I-601's at $930,
yeah.
and the second you file it, you've really changed up your case.
Sort of a commission kind of thing of some sort of.
Yeah, I think you can file a 601 without admitting fraud and
Yeah,
just like saying should USCIS disagree. But yeah, it's hard. It's a
yeah,
pain in the butt.
I hear you. We've had the discussion about 601s before. It's just an annoying thing. Hopefully, IRIRA changes. I mean, the 3 to 10 year bar and the waiver for that, the 601A is one thing that came out with IRIRA back in the 90s. But I'm guessing fraud has always been an issue. I mean, there must have been a waiver because the 212 section must have been existing before IRIRA, I'm guessing.
Fraud has been an issue. Fraud's been there for a very long time. The false claim to citizenship came in with IRIRA, but the fraud has been there for a long time.